by the Center on Reproductive Health, Law, and Policy at UCLA Law. I am very excited to have you all here, and I'd love to introduce you to Melissa Goodman, who is the Executive Director at the Center.
Thank you so much, Carly. Oop, are we still in the right view? Hi, everyone. It is very nice to be here with all of you. Thank you so much for taking the time to join us today. I'm Melissa Goodman. As Carly said, I'm the Executive Director of the Center on Reproductive Health, Law, and Policy. And just 2 seconds of background on the center. The center is a nationwide think tank and research center created to meet the national crisis in abortion access, while also working towards long-term solutions to advance reproductive justice. And we do forward-thinking, but also practically useful legal and policy analysis. We develop legal and policy models and theories, and we conduct quantitative and qualitative research, and we produce publications to help create concrete change to advance reproductive health, rights, and justice. And one of the things we do is author amicus or friend of the court briefs in important cases. And we did author one this term for the abortion pill case that we'll talk about today in collaboration with Dr. Upadhyay and her colleagues at UCSF, and on behalf of over 300 reproductive health researchers. So with that said about the center, we are here today to discuss the Supreme Court's term and what it means for abortion access. And from my perspective, though, I'm very interested to hear what everyone else will say about this. You know, for me, the theme of the term was dodge, and so further chaos and uncertainty. And on the surface, both abortion cases might look like victories, and they do have good immediate results. In one case, continued access for now to the abortion pill under current FDA rules. In the other case, temporarily allowing Idaho providers to perform stabilizing abortion care to preserve patients' health in emergency situations, as is required by federal law. But these cases were decided on process or jurisdictional grounds rather than on the merits, and they're really not true victories, but from my perspective, harmful delay. And really, the anti-abortion movement's work to stop access to abortion pills will continue with more lawsuits and new tactics, because ending abortion pill access, and especially by telehealth, as we'll talk a bit about today, is key to their short-term goal, is one of their key short-term goals on the way to their larger goal of banning abortion nationwide. And really, they won't stop fighting even emergency and life-saving abortion care. Some would say that the Supreme Court's actions on the abortion cases this term were tactical decisions to wait on big abortion action until after the election, because they know, like all of us do, that the next election is hugely consequential for the direction of reproductive freedom in this country. And as we'll discuss more today, this election cycle could be the difference between whether or not we have a national abortion ban, whether or not we have political or judicial branches trying to impose old zombie laws to block mailing of abortion pills, whether we see more embrace of the concept of personhood to grant fetuses, or even, as we saw in Alabama this year, embryos outside of a body, full legal rights as people that trump a living pregnant person's rights, with possibly devastating consequences for abortion, but also fertility care, contraception, and more. So we'll be talking about all of this today with an incredible, brilliant array of panelists who come to us with expertise on constitutional law, abortion science and data, and medical practice. And I'm so excited to have you all here. And I'm going to actually ask that you each introduce yourself briefly, and what about your life, your professional work brings you to this conversation and sort of the perspective that you bring today. And Dr. Upadhyay, I was hoping to start with you.
Sure. Thank you so much for inviting me today. My name is Ushma Upadhyay. I'm a professor and a public health scientist based at Advancing New Standards in Reproductive Health, which is at UCSF. And my area of research focuses on abortion safety and access. And right now, a large area of my focus is on telehealth abortion, specifically the safety, effectiveness, as well as acceptability and how it has impacted people's experience of abortion care. And then I'm also co-chair of We Count, which is a project of the Society of Family Planning, which aims to understand the impact of the Dobbs decision on the monthly number of abortions in the United States by month and by state. And so that really gives us a really nice perspective of the national abortion rates and the impact of Dobbs.
Thank you so much. I'm going to go next to Dr. Cooper.
Hi, thank you for having me today. My name's Kylie Cooper. I'm a maternal fetal medicine physician and assistant professor of obstetrics and gynecology. So as a maternal fetal medicine physician, I care for those with high-risk pregnancies, which includes people with pre-existing medical conditions, those who have fetal diagnoses or abnormalities, as well as pregnancy complications, and often it's combinations of all those things together. I, in 2018, moved to Idaho to work as a maternal fetal medicine physician there, and I was there until spring of 2023 when I moved myself and my family to Minnesota because of the abortion ban in Idaho.
Thank you so much for sharing that. Dr. Gustafson, it would be great to hear from you.
Yeah, hi, thanks for having me. My name's Caitlin Gustafson. I'm a family physician. I work in rural Idaho where I practice full spectrum family medicine, including obstetrics. I've been in Idaho for about 20 years now, including my residency in Boise, and then moved into this rural area where I've been for nearly 2 decades now. I've been an abortion provider for Planned Parenthood over the course of that time, and then I became involved in physician advocacy, specifically around abortion care and reproductive health. Probably tipped off the most in around 2018, 2019, when I was a declarant in a case challenging the REMS criteria against the FDA. And then on to challenge the Idaho abortion bans as a named plaintiff with Planned Parenthood in those state cases. And since then, I've just been deeply involved. Over the last year, my work in advocacy has primarily been as the co-president of the Idaho Coalition for Safe Healthcare. And that work goes on to this day.
Mm-hmm. Excellent. Thank you. We'll definitely talk about that later. And last but not least, Professor Franklin, we'd love to hear from you.
Hi, I'm Carrie Franklin. I am a constitutional law professor at UCLA, and I am the faculty director at the Center for Reproductive Health, Law, and Policy and at the Williams Institute, which is an LGBTQ+ think tank. I am going to go super broad and just say, well, first I'll say, my work is largely on discrimination and making sure that the liberty and equality guarantees of the Constitution are enforced. I'm just going to say at its broadest, I am in constitutional law because I believe that we broke free from a king and we wrote a constitution that begins with we the people. And it is incredibly important to understand that we the people control and we are making the society and the laws. And it makes me angry and frustrated when that vision of the United States isn't realized. And I am working in my own small way to make sure that that can happen.
Well, thank you. And thank you for that inspiring start. From way up there to like, what is the purpose of our democracy and our freedoms? I'm going to take us down a little bit into just a few minutes so our panelists don't have to do this, to make sure everybody has the same sort of basic understanding of the main cases that we're going to talk about today. I do want to say before I dive into this, I want to acknowledge, because we have a very short amount of time budgeted for this conversation, it is highly unlikely that we are actually going to have time for questions at the end. However, it is possible. So if you have a huge burning question and you'd like to ask it, please put it in the Q&A. It's possible, you know, if it's fast and simple, people might be able to answer it also during the conversation in that Q&A box. But I wanted to set your expectations to know that we have a lot to cover and we might not get there, and we apologize, but there will be more conversations to come. come. So quickly, I mean, as quickly as one humanly can, I will summarize. First, FDA, the Alliance for Hippocratic Medicine, and this case was about access to mifepristone, which is one of 2 drugs commonly used in medication abortion, which now accounts for 63% of all abortions. That's new data as of the last few months. Because of mifepristone's overwhelming safety record, in 2016 and 2021, the FDA, which is the Food and Drug Administration, lifted some medically unnecessary restrictions that it had on the drug. And the most important changes included allowing dispensing of the drug via telehealth rather than requiring people to go in person to get it dispensed, and also permitting provision of the drug by a range of healthcare providers with prescriptive authority under state law rather than just physicians. And this significantly increased access. Anti-abortion doctors formed an organization called the Alliance for Hippocratic Medicine, and they filed a lawsuit arguing that those rule relaxations, among many other things, were based on insufficient evidence. And the district court and the Fifth Circuit, the first 2 levels, agreed. Got to the Supreme Court, and the Supreme Court didn't decide if the FDA rules were valid. Instead, they reversed the Fifth Circuit based on standing, which is a legal concept that requires anyone bringing a federal lawsuit to demonstrate basically that they have a real personal stake in the case. They have an actual or imminent injury that they are suffering. They're suffering because of the thing they're challenging, and the injury that they have is something that a court can actually fix and do something about. The anti-abortion doctors argued that they were harmed because the FDA rules meant more people who had taken mifepristone would end up experiencing what are extremely rare, as we will hear from Dr. Upadhyay later, extremely rare adverse events, and then have to seek emergency care that these doctors may be required to treat, and doing that treatment would harm their conscience or cause them some kind of emotional distress. The Supreme Court correctly held that the anti-abortion doctors do not have standing because they don't actually prescribe mifepristone. They've never had to treat a patient experiencing a rare serious adverse event from mifepristone over their objection. And they presented no evidence that the FDA's actions actually increased the number of people who'd be seeking treatment from these anti-abortion doctors that somehow diverted their time and resources away from other patients. So that, in a nutshell, is the mifepristone case. Moyle, which is what is more known as the EMTALA case, is a case that concerned a conflict between federal and state law. So Idaho, as our Idaho experts here will talk about more, has one of the strictest abortion laws. And essentially it says providers can only provide people emergency care if they're certain the patient will die. This is a clear violation of federal law, a law known as EMTALA, which says that hospitals with emergency departments that receive Medicare funds must provide stabilizing treatment, including abortion care, if it's needed to prevent grave harm to a person's health. That could be things like loss of organs, loss of future fertility, or the need for lifelong treatment. Federal law says you have to do it. The DOJ, the Department of Justice, filed this lawsuit against Idaho, seeking an injunction to allow patients to receive emergency abortions as required by the federal EMTALA law, because typically in our federal system and pretty clear established constitutional law, federal laws win out in these situations. So what happened in the Supreme Court is interesting and complicated, but in a nutshell, the court decided it was wrong to take the case so early. It had taken it in a really weird procedural way, and it sent the case back to the lower courts without deciding whether EMTALA or state law wins here. It did dissolve its stay in the case, and that means for now, under a lower court injunction, Idaho has to follow federal law and providers can give emergency abortion care. But as the case proceeds, providers will remain without a clear legal answer and continue to practice at great risk. So those are the 2 main cases we're going to talk about today. Because other things might come up, I just want to spend 30 more seconds to lift up 2 other things the court did last week or the week before. Very briefly, I just want to highlight another case that people don't talk about it as an abortion case, but I think it has some important things for people to pay attention to for the future. It's a case called Munoz. It was an immigration case where the court said a U.S. citizen doesn't even have to be told specifically why the government is depriving their non-citizen spouse a visa or legal status to be in the country with their spouse. It's not about abortion, but it is an important reproductive justice matter. The court said that there's no liberty interest at all in being with or living with your family, contrary to very firmly established precedent. It's continuing the court's trend of narrowly interpreting liberty, defining a right in the most narrow way possible and saying, oh, there's no history or tradition about this very specific and narrow right in this country. And I bring it up because I also, many people think, including Justice Sotomayor, who wrote a strong dissent, thinks it is a roadmap to how the court is in the future going to cut the fundamental freedom to marry, including for same-sex couples. Lastly, the court took a case this week on Monday challenging Tennessee's ban on hormone therapy for minors. The question the court will decide is whether banning such care violates the Constitution, and I point it out only because it's hugely important for gender discrimination law and the abortion landscape. So with that, we will discuss. I want to start generally talking about how in overturning Roe and Casey in Dobbs, the Supreme Court said that it was returning the issue of abortion to people's elected representatives, but Dobbs left vast uncertainties, and now they've left more uncertainty with the cases I've just talked about. So I have some questions here, and I want to start with Dr. Cooper and Dr. Gustafson here. Generally, how have the uncertainties regarding the Supreme Court's recent cases affected your practice of medicine and your patients' experiences? I'll let you decide who'd like to chime in first.
Maybe I'll take this one first, Kylie, if that's okay. I can speak generally to the fact, I mean, there's so many levels on which this has been, affected our medical system, but I think of it in two buckets, essentially. One is the uncertainty and confusion that we've seen that's played out at the bedside, whether somebody is coming in directly for a pregnancy complication or a reproductive health matter that links in. And what I mean by that is the clash of medicine, how it's really practiced, and then the lines that are drawn by our legislature versus what we really need to do and say and provide for patients at the bedside. And there's lots of examples of this. I think of first trimester pregnancy loss, which is something, family docs take care of frequently, as do ER docs. There's just been an overall reluctance to definitively diagnose miscarriage that's really come and been born out of these abortion bans. It's terrifying to doctors because they feel that making that diagnosis can put them in the crosshairs of the law. And don't forget, in Idaho, we also have a vigilante provision, which means that, our patients or family members of our patients can sue us for coming in conflict with the abortion law, as a matter of managing a miscarriage in the way that standard of care and that we would do. And then the other part of this is the impact on the system of care, which has far-reaching effects beyond the bedside day-to-day effects that we're seeing as doctors. And that is, an example, or there's so many examples of that, but right here, on this call, Dr. Cooper and I worked in the same hospital system. 5 of our 9 maternal fetal medicine docs left the state after Dobbs. That's a whole system of care that's broken down. As a rural physician, I depend on those conversations with my MFM docs, with my OB colleagues. So we've seen a real crippling of the system of care that depends on consultation and safe transfer of patients for high-risk OB conditions. We say in rural medicine, there's no real such thing as low-risk OB because at any moment, OB can become high risk. And so when you're practicing out in a small hospital where you don't have resources, you're really dependent on those safe systems of care. And that has been just broken down in so many ways. I'll hand it over to Dr. Cooper.
Yeah, and I think in addition to what Dr. Gustafson mentioned, as far as like management of early pregnancy loss and even ectopics initially with the total abortion ban, so just has had wide-reaching ripple effects on pregnancy care. I think speaking as a high-risk obstetrician and abortion provider, in Idaho at the time, just my world was turned completely upside down. And as Dr. Gustafson mentioned too, like just the root of the issue is this ambiguity and uncertainty, that in the context of these bans. So I think as medical providers, we're trying to understand how a legal definition that's been determined by legislators applies to that person, lying in that hospital bed, suffering a pregnancy complication, through no fault of their own. And every patient is an individual. And so they come to us for help in some of the most heart-wrenching, scenarios imaginable. And so for patients, patients are afraid. They're afraid to become pregnant. They're afraid of having a recurrence of past pregnancy complications. They're afraid of needing to be sent to another state for care, without their loved ones by their side. And some patients, early on, like they're afraid to even say the word abortion. They're like, can we even talk about it, in my office? So, instead of being able to provide that continuity of care as their trusted doctor, my patients had to leave the state, start over with a new face, being kind of re-traumatized all over again. And, I ultimately made the decision to leave pretty early on after the ban went into effect. But I having been in touch with my former colleagues, and just having been there for a period of time, just the moral distress of having your ability to provide this evidence-based medical care taken away and having to send your patients away, it takes like a small piece of your soul.
Mm. Thank you, both of you, for sharing that. It's a very painful reminder of the toll it takes. So thank you. Dr. Upadhyay, I want to ask you from your perspective as a researcher, has uncertainty regarding what the Supreme Court is doing here, affected from your perspective abortion access generally? I know you mentioned being involved in the We Count study, so you have your finger on the pulse there.
Yeah, so what we're hearing from patients is that there's tremendous uncertainty about the legal risks that they face. So many of the participants here today probably already know, we can talk about it more later, that there are providers that are mailing medication abortion pills into states with abortion bans. So while those reduce the legal risk for providers, there's tremendous uncertainty for patients what legal risks they are facing by ordering these pills. A lot of patients are concerned about digital surveillance, what measures they should take to remove any evidence if they're ordering these pills online. And then also there's questions. Self-managed abortion is not limited by law. I think in the vast majority of states, I think there might be only one state where self-managed abortion is restricted. And so it's unclear whether, if they were found out, whether they would be criminalized. And of course, you all, the lawyers on the call, can maybe talk about this more, but many laws are invoked to criminalize people even when there isn't a specific law criminalizing self-managed abortion. So that's where a lot of the uncertainty is. And then one more place of uncertainty is the legal risks of traveling for care. There's a lot of discourse. Alabama is one example. In Texas, there are some counties that are proposing these laws banning travel for abortion care to other states. We know now there are 170,000 people who traveled out of state in 2023 alone to obtain an abortion. It's a huge number. And many of those people are worried, what is more legally safe, ordering the pills online or traveling for care? There's just no clear answers. And also we're hearing that patients don't want to tell their friends and family that they're going through this process. They're experiencing taking the medication abortion at home alone, not because of the stigma, which is what we usually think, but because they want to protect their loved ones from any potential legal risk.
Thank you for that. Professor Franklin, I'm going to turn to you for the legal perspective here. Dobbs obviously unsettled really long-standing constitutional law. And from your perspective, what have some of the repercussions been so far, and some foreseeable future implications related to reproductive health?
Yes, they are many. So for 50 years, we had a doctrine that took into account people's liberty and equality interests and the state's interest in potential life and tried to balance those. And then Dobbs came down and changed that test entirely to one that looks to the 19th century and the regulations that were in place at that time and the quote history and tradition of how it was regulated in the period that we changed the Constitution to protect liberty and equality. So I'm not surprised to hear Dr. Upadhyay say people are confused about this. They are right. They are reading the law correctly. It is wildly uncertain how Dobbs will apply to life-saving abortions, to health-preserving abortions, to contraception, to abortion, contraception that's now going to be redefined as abortion, such as IUDs, how it would apply to the pill, how it would apply to embryos. Now, and part of, you can see why this is difficult and confusing, and I can't give you the answer, is what did the white men who were controlling the laws in 1850 think about the status of embryos? What did they think about IUDs? They didn't write about that because they didn't know anything about that. So we're in a game of trying to read old treatises and interpret history about men who never made comments on any of this. So it is very difficult to do. It is very open to discretion. It is very unsettling. And what you are hearing from all of my medical colleagues who have spoken is chill. It has chilled the practice of medicine because no one, even the constitutional lawyers, can say for certain what the court is going to say about the white men who could vote and make the laws in 1850 and what they thought about embryos. And I'll say, I think the result will probably resemble something close to what the 6 conservative Supreme Court justices actually think about embryos, though they will attribute their views to the guys in 1850. So one thing is chill on the ground in the effect of medical care. And I'll just end by saying the other thing is what I started with, a massive hit to democracy. And it's very frustrating to many of us in constitutional law because the court framed the shift in Dobbs as a democracy-enhancing shift. We're going to kick it back to the states and they're going to decide. That is wrong every which way, in part because states are so gerrymandered. We have legislators that don't actually represent the people and reflect the view of the people. These bans, these draconian bans that are going on, are not supported even by voters in red states. When some state democracy starts to get off the ground, the anti-abortion movement is frantically working to shut down referendum, direct democracy, opportunities for voters to speak their mind because they know that the voters don't agree with their views. And finally, it doesn't actually kick any of this to the states. The Supreme Court is going to decide all of these questions. That is 6 people sitting in Washington who are going to decide for the entire country all of the questions that have been raised. So when they frame democracy as the people decide, let's put it back to the states, it is a gaslighting, I guess is the term that is currently in use for this kind of discussion, because it is a massive power grab by this court who will eventually provide answers to all of these questions.
Thank you for that. Sobering as it was, I'm going to shift us to talk briefly about the abortion pill case. And Dr. Upadhyay, I'm going to start with you and I guess ask a question that relates, but maybe together. We already talked about how the case is about that the case that they brought is really not grounded in science. And we were hoping that you could spend some time just briefly describing your research related to the safety of mifepristone and also medication abortion via telehealth. And given that research, what you sort of make of this continuing effort to challenge abortion pill access via safety arguments, and sort of in addressing that and talking about telehealth, why, from what you're seeing, why is sort of telehealth access so important?
Yeah, absolutely. So through WeCount, we know now that 19% of all abortions, that's 1 in 5, are occurring through telehealth. So medication abortion, I'll start with medication abortion. It is, Guttmacher has told us that about 63% of all abortions now are done with the abortion pill. So it has taken on tremendous importance. We know that over 100 peer-reviewed articles have studied the safety and effectiveness of mifepristone. It is extremely safe. In-office care, we looked at Medicaid data, and we found a serious adverse event rate of less than 1/3 of 1%. So it is extremely safe. And that's what just blows my mind, that they keep coming up with these cases trying to bring down the abortion pill based on safety arguments. There's no evidence there. None of these articles are saying that the abortion pill has any concerns about safety. So the one article that they point to, one of the bad science articles, discusses the high rate of emergency department visits after medication abortion relative to procedural abortion. And that's because, as I said before, when someone takes the abortion pill, they're taking it on their own, whether they pick it up from a clinic or they receive it in the mail, they're going through the process on their own. And frequently they'll go to an emergency department because there's no nearby abortion provider that they can go to assess whether bleeding is appropriate or not, or to check to make sure that the pills worked. They'll want an ultrasound or a test. And so other research we've done finds that half of all emergency department visits result in no treatment at all. So relying on an emergency department visit alone is not an indicator of safety, but that's what the antis use to tell people that there are safety concerns, and it's just not true. So that's kind of the science. So we also recently completed a study on the safety and effectiveness of telehealth abortions. We followed 6,000 patients who use the service over the course of 6 weeks, looked at follow-up visits, and we found similar rates of safety and effectiveness as when they get their pills from a clinic. And so study after study, and this is consistent with other studies that have been done, demonstrating the safety of telehealth abortion. And so right now it is really the critical difference for people living in states with abortion bans. And so that's why it's so important that everyone understand how safe it is. There may be questions about the legal risk, but the medical risk is minimal, is almost negligent.
Thank you so much for that. I'm going to shift gears back to the law, and Professor Franklin, sort of a compoundish question for you. Although there was a sort of favorable outcome, which just means no vast immediate harm in this case, I guess I'd love you to talk a little bit about sort of what you think will happen next, and I guess in two ways. There's a concern, that the case might continue at the district court because we've seen state interveners enter that case. There could be more challenges by different plaintiffs who make different standing arguments, or we can see different attacks altogether. I'll note that in the oral argument, in this case, some of the Supreme Court justices expressed interest in the Comstock Act. And you can talk about what that is and what that means, but sort of legally speaking, where do you see this kind of going from here?
Ooh, that's a big one.
Yeah.
I don't think my guess is this case is not over. The court simply said this newly made up organization of doctors that was not involved in providing abortion care at all had no standing to challenge this because they had no kind of skin in the game. You're not allowed to come to the court if you have no involvement. But now 3 states are trying to intervene in the case, saying we do have some involvement because we may end up paying for some of the people who come to these emergency rooms and seek uncompensated care. We have laws banning these pills. This is making it harder. They have better claims than the doctors who tried to do this. So I think that these people will probably progress and this case will make its way back. I think this is not over. This was just, these weren't the right people to bring the case, but there probably will be some people who can bring this case, and we're going to hear this challenge, and we're going to reach the merits of the question on the case. So we'll just see, it's just correct that the studies are all on one. So the reliable peer-reviewed studies are all on one side. This medication ranks down, I think, either equivalently or below Tylenol and Viagra in terms of risk. So it is really made up set of arguments about safety. It's really dismaying to me. I know some of the people on the other side bringing this case, and it's just one of these eternal mysteries to me how they can lie about the science. I just feel like there's a basic ethical baseline that as a lawyer you shouldn't fall beneath, and they seem to be doing that. I don't know. But that's what's happening. Whether the Supreme Court will buy that, we'll have to see. I'm not going to make predictions about that. Let's just say I'm not feeling great. Not feeling great about getting a complete victory for science and safety and care in that case. Though there are some reasons it may not be the worst outcome possible, including that all the drug companies in America are freaking out that the Supreme Court might countermand the FDA's long-standing process for approving drugs. So there are some powerful folks who aren't necessarily always intervening on the side of reproductive healthcare who may do that in this case. And so it's going to be a hard-fought case. I will just shift now to one of the big things on the horizon, which is the Comstock Act. Comstock Act is an 1873 obscenity law brought by an anti-vice, anti-pornography, anti-sex crusader from the 19th century named Anthony Comstock. He hated people having sex. He even hated married people having non-procreative sex. He really wanted women to start covering their ankles and stop looking at dirty pictures, dirty books, including information about birth control that might make people have sex. Ugh, dirty, bad sex is wrong. Okay, so Congress passed a statute barring the sending through the mails of obscene materials. This was viewed as an anti-obscenity statute. He was mainly trying to get at dirty pictures and birth control information that might cause people to have illicit sex. That was the aim of the statute. Now, the anti-abortion forces are trying to reinterpret this statute as a nationwide abortion ban, the argument being that this statute prevents the sending in the mails of any item that might be used for an abortion, which would include medication abortion, but would also include any implements, tools, medications used in surgical abortions as well. So this statute, let me just be so clear on this. This statute was never understood as an abortion ban. It was not understood to interfere with health care that doctors were providing to patients. Doctors' receipt of medical equipment or medications that they were using on their patients. They were not being prosecuted under the statute or subject to the statute. It was people sending dirty pictures. It was not understood to apply to the practice of medicine. Because the anti-abortion movement is so unpopular and they cannot pass a national abortion ban, they are trying to circumvent the American people and use this 1873 law to say, guess what? Nobody knew this, but we already completely banned abortion in this country. Surprise, it's been banned for the last 150 years. That, as ridiculous as it sounds, don't laugh. This is a very serious move. And several Supreme Court justices have already signaled that they're extremely anxious to hold that Comstock bans abortion in this country. I don't know if there are going to be 5. There are more than makes me comfortable. So stay tuned for Comstock. It's coming down the pike.
Thank you for that. Again, sobering. I'm going to shift us now to talking about the Idaho case. And I'm going to turn particularly to you, Dr. Cooper and Dr. Gustafson. You touched on this a little in the other question, but I think it's really important for people to understand kind of in a real way, what this means. Kind of a compound question for you too. There's a good aspect of this case, right? That is now going to sort of temporarily, at least, allow Idaho providers to perform stabilizing abortion care. But it now has to happen still within the framework of medical providers and healthcare institutions not knowing what the ultimate kind of legal answer is to whether like EMTALA wins or Idaho state law wins. And then providers, you all are in the middle of this with a patient in front of you in an emergency situation, trying to make a decision. You touched on this a little bit, in your earlier answer, but would love to hear a little bit first, whether you think, so this outcome, at least temporarily allowing these things to happen, will have some positive effect. But, more big picture, what does it sort of look like in your practice to not know yet, but also potentially have to operate in a world where maybe Idaho's view of the law will win, and that means waiting until your patient is pretty certain to die to give care? Just like to give a little color to like what that actually looks like, and was this a good thing or bad thing for folks in Idaho? I also want to point out, I know the court relied very much on an excellent amicus brief that you all worked on from the Idaho Coalition for Safe Healthcare. So I know it talked a lot about this. Anyway, that was a very complicated question. I apologize, but would love if you would sort of comment on that generally. Not sure which one. Oh, there we go.
Dr. Cooper, you want to take painting the picture? And this is really, MFM scope of care. So I really can defer to Dr. Cooper to sort of paint the picture of, how many, I would first say, I think any physician in our position would agree, any patient that's getting care today in Idaho that wasn't yesterday, or now has it been 2 days? I'm losing track. It's been a week. Anyone that's able to get care now because we got this very temporary brief moment of relief. I can speak to that having been here on January 5th and when the court took up the case and our injunction was lifted, and what that felt like. It felt to someone like myself who is always going to be calling an MFM like Dr. Cooper in these cases and consulting with her, but at that, the first line level at of a patient, knowing that a patient could come in on my watch and I would be in this situation, it felt quite dramatic. And then to stay in that place for the last 6 months where our MFM colleagues that are still here in the state were literally airlifting patients out of the state in these situations, it was dramatic. And so that moment has ended for the time being, but now it's settling in that we could be right back there. And that creates a lot of unease and probably further instability to our system of care here.
Mm-hmm. Dr. Cooper?
Yeah, and I think, it's like a small moment to catch your breath, right? So in that way, obviously I was relieved to hear the decision, but, we all know this will continue to be a threat, to healthcare. And, as someone, was practicing, from 2018 to 2023, under the ban, I cared for the sickest of the sick when it came to pregnancy complications. I worked with Dr. Gustafson and many other providers across the state and this large network of obstetrical care. And, we got those patients sent to us, and I was privileged to care for them. And, we're trained, we have training, knowledge, expertise, and experience. And when you're encountering an emergency, you use all of those skills and you care for the patient. You mobilize your teams, you do, give them blood transfusions, medications, everything you need to do. You move towards an abortion procedure, expeditiously in an emergency when the patient is early and before there's a viable fetus. And so with the ban, it just added this immense weight. So instead of being able to focus on, the patient in front of you just 100%, you have this like voice in your head, this pit in your stomach where you're like, is this the moment? Is this the moment that I am committing a felony and could get charged with a felony? And I'm thinking about my husband and my 2 daughters and, imagining, just worst case scenarios about if I go to prison, but yet I am never going to let something bad happen to someone who's under my care, who's in front of me, who is a human being with, a family and a life. in dreams. And so it was just immensely, distressing to be in that situation. And that is something that I have never, in my career encountered before, where I couldn't just do the right thing, just do the medically appropriate thing. And there were, potential delays in care. You're having to call attorneys, and say like, hey, these are the circumstances. Like, what do you think? I know my colleagues are flying patients out of state to get the care that they need, before they get in a situation where it's an emergency and the patient's in big trouble. Whereas before they would have been able to get that care at the hospital. We were able to handle pretty much any pregnancy complication. And you don't know how things are going to go. So one patient with preeclampsia may have completely different symptoms than another patient. No two people are the same. And so trying to predict, when can we call it, preventing the death of a patient, there is no number for that. Is it a 5% risk? Is it a 90% risk? So that's just not, that definition is just not based in modern medicine or in reality.
Thank you for that. I have one last question about this case before I want to kind of go to two last questions and get all of your thoughts. But Professor Franklin, I just wondered briefly, from a legal perspective, I think a lot of people are sort of scratching their head about what the court did here. Most people have not heard of this thing of improvidently granted. Could you just talk a little bit about, also some people I think are confused about whether we can read anything into the opinions that indicate sort of how the justices may ultimately decide the merits question here, which is, does EMTALA actually preempt a state ban? Do you have any sort of read based on what the justices have said, what might happen here on the merits, or what any of this means to unpack it for people?
Like the other case, this case is not over. What happened means that it will just go back to the lower court and will go through the normal process it would have. So this wasn't at all a decision. It wasn't an end to the case. It wasn't a partial end to the case. It just means the case will proceed normally. The Supreme Court dove in really quick and just took the case out of the lower courts. Now they said, oops, we shouldn't have done that. They didn't apologize to you, doctors. I'll just apologize to you. And one of the justices said, I'm so sorry we put you in this position for the last 6 months. But the Supreme Court mostly didn't apologize. Anyway, they said, whoops, we shouldn't have taken it. Now it's going to go through a normal channel and we're going to get a decision, and it may very well. In fact, I think it will, whether this case or a different EMTALA case, I think it will get back to the Supreme Court because there is a fundamental conflict, which is that this law says if somebody is in severe distress, medical emergency, their life is at risk, their health is at risk, you have to provide them with stabilizing care, including an abortion in the case where that is the indicated stabilizing care. But there are states like Idaho and Texas that say, no, you can only provide that stabilizing care if the life is at risk. So there are lots of situations where it's unclear, or where clearly the risk is the person might lose organs, the person might lose their fertility, the person might have serious health consequences, but a doctor is not going to feel 100% certain that the person's going to die, right? It might be that they're just their body will be severely damaged. And Idaho and Texas say, you can't perform an abortion with that damage we don't allow. So that conflict still exists between the state law and the EMTALA. That'll get back to the Supreme Court. I don't like to predict what the Supreme Court is going to do. I will say there are some troubling signals, which is that there were several conservative justices who are angry. They wanted to just hold that the federal law could not preempt Idaho's ban on health-saving abortions. So they would have just resolved the case, and this is Justice Alito, Justice Thomas, Justice Gorsuch, they would have just said, no, the federal government can't tell Idaho what to do. If it's criminal to save women's uterus or pregnant people's uteruses or preserve their fertility, that it's criminal and you can't do it. And you will go to prison if you do, potentially. There were the other three conservative justices said, no, we need to hear more about it, let it go through. But we're skeptical that the federal government actually has the power to pass this law. We think this is trenching too far on the state's customary ability to control criminal law and to criminalize certain procedures and to control the practice of medicine. They signaled their interests, their strong interest in that argument. That does not sound like a court that is ready to say, no, the federal law that says you have to protect people's from serious health consequences should stand. So I don't think anyone should view this as some sort of signal that things are going to be okay and that people are at lesser risk. I think it's a delay. And I think the signs, if I had to say, don't look very good to me. I think it's a frightening. There are some frightening portents for care in this country and for well-being.
Thank you. I decided we have time for one more question before we get to our concluding question for everyone. And this is directed either to Dr. Cooper or Dr. Gustafson, because you both raised in some way, shape, or form also your own personal decisions. You're operating in these environments. Do you stay or do you go? And it's having healthcare workforce impacts. And I just wondered, in a transition to sort of the concluding thoughts section, I just wonder your thoughts on sort of the broader impact for wider kind of maternal health care, that you're all put in these terrible positions now to decide whether to keep practicing in these environments or go somewhere else. And do you have concerns that it's going to change the face of the healthcare workforce, where it is and how that's happening? And then I will turn to the concluding question. Do either of you want to take that one? I'm sorry, I didn't want to choose for you.
Kylie, do you want to go ahead? Dr. Cooper, you want to go ahead and I'll add on? Yeah.
So in kind of realizing what the future might hold as a maternal fetal medicine physician in Idaho, and not being able to care for my patients in the compassionate, medically appropriate way that I was trained to do, I realized like there was no way that I could continue to work in Idaho and raise my family there. And I think as a woman, as a maternal fetal medicine physician, and as an abortion provider, like I certainly felt like I had a target on my back. And so ultimately, yeah, we made the really difficult decision to leave the state. And, it's been been almost a year and a half now, and it's still a decision that I struggle with very much. I'm in an abortion productive state now, which has been, just be able to breathe and feel like I can go back to just providing medical care as I always had, before, and providing care for patients from surrounding states who come, to Minnesota. That's been, rewarding, and certainly I've been able to care for a lot of patients. But, working with amazing people like Dr. Gustafson and just people around Idaho, we as MFMs are part of that safety net for obstetrical care. And by leaving, that's one fewer MFM provider to be a resource for them. And so I have certainly guilt over that. In the end, leaving was the right decision for me, but I certainly worry about the safety net and just kind of the utter implosion of reproductive health care in the state of Idaho.
Yeah, and I would just add on to that. I'm in a completely different situation. I'm a family doc with a full spectrum of care beyond obstetrics. While I don't want to stop providing obstetrical care, because I've been doing that and have generations of families here in my town and my area that I've been caring for and love that part of my work. As a family doc, I have an option to stop practicing OB. That's not a great option for the system of care, because we're seeing this happen. If you lose one of 4 providers in a town and a rural hospital, that can take out a whole rural labor and delivery unit. Like, it's hard to sustain a small hospital when you lose even 1 or 2 of the docs. And so I feel very, I'm grateful. I have a very, at the moment, stable group that, despite this ban and despite the the struggles. I still have a group that I can practice in, that we can hold up this work together. But as Dr. Cooper said, and you've been hearing today, you know, we lost a lot of our MFMs. We're struggling to have that system of care. 22% of our OBGYNs have left. And it's, you know, as a family doc, we're dependent on that system of care and that higher level of care and expertise when we need it. And so that makes the practice of rural obstetrics scarier all the time. And so I just say to myself, we have to take it day by day and see what happens. And I want to stay here and care for our families, but the state is making it harder every single day. And I'll just add one last thing, because the chilling effect was brought up today. And that's exactly what's going on here, is just that level of fear that people have, that you don't have to practice like that. You can go to another state. You can choose to practice somewhere else. There's no OBGYN residency in our state. So anyone that, you know, gets trained or wants to practice in Idaho, they're coming here because of some other connection here, not because they trained here and ended up staying here. We have to depend on that outside draw in, and we've lost that. Who in their right mind would come in to our state and stand up to this, and to an attorney general who is literally gaslighting us every day.
Thank you for that. And for folks watching, watch from the center for more research coming on some of those healthcare impacts. But thank you both for your service and the places you're doing it. I'm going to conclude this conversation with a question, and apologies to folks that we can't get to the questions, but there was so much good things to discuss here. I'm going to ask each of you. I'll call on you in turn. I guess briefly, you know, in light of this discussion, I'd like to know two things. One, given all of this, what are sort of your views from your perspective about the importance of the next election for abortion and reproductive healthcare access? I'm not asking that in a partisan way. I'm asking that in a kind of policy way, like what impact is it going to have in your lives? And then is there anything out there that's happening on this front that is making you hopeful? I'd like to ask each of you to answer with that. And I'm going to start with you, Dr. Upadhyay.
Okay, I'll be quick because I know our time is limited. In terms of the elections, I don't believe for 1 second, as I'm sure no one does, that Trump supports abortion pills or thinks that they're okay. Not for a second. I also have concerns about Biden wanting to restore Roe. So really huge concerns, because Roe was actually just the minimum. You know, there were so many people who weren't able to get abortion care when Roe was the law of the land. And I think that's why we're seeing this massive increase with telehealth, because so much unmet need in the blue states is now being addressed. It's not coming mostly from the red states. I think it's a lot of the unmet need in blue states. So those are my thoughts about the election. It's critical, but there's so much more that can be done. In terms of what keeps me hopeful, I think it's the bravery of the providers that are continuing to offer care to folks living in states with abortion bans, those working under shield laws. That gives me so much hope.
Thank you. Dr. Cooper, I'm going to go to you.
Yeah, I think in terms of the election, yeah, it's going to be a pivotal, moment to see, which direction things go. And I worry not just about abortion care, but as we talked, contraception, fertility care, trans care, all these things. It's just going to be just a really, really important election. I think things that give me hope, people like Dr. Gustafson, who continue to it's going to make me cry, who continue to work in these states under these bans and caring for patients. And then I think also Justice Jackson's opinion, reading that gave me hope, because, having advocated and trying to have conversations with legislators as a literal pregnancy expert, that is what I do all day, every day, trying to explain to them like facts and like real patient stories and real scenarios that they are unaware of, and try to explain how this is so harmful for people, and not feeling heard at all. So I think reading her opinion, it was powerful. And I felt heard in that moment.
you for that. Dr. Gustafson?
Thanks. I'll just echo all that. I'll just be super honest about the election. It's just one big, huge pit in my stomach. You know, like many of us, I'm just terrified of, you know, the fact that this country could go that direction on so many levels. So I'll pivot to hope because, yeah, I wouldn't be staying if I didn't have it. I think this issue, I really truly believe in my heart, this is changing medicine, particularly around abortion care and the conversation. This was such a siloed aspect of medicine forever. I trained under that. It was like a don't ask, don't tell that you're an abortion provider, especially in Idaho, but I know it's like that in other parts of the country. And we've been saying the word abortion in Idaho, you know, so hundreds of times more than were said here over the previous 2 decades, you know, that I've been here. And I think that's positive. And it's positive to the end of it's coming back in there's a wake up call that is happening, not with everybody, but with some, and even within our own field of medicine, that it is healthcare. Hello, it's healthcare. And when you take a piece of healthcare out, the trickle down effect and the nightmare that that causes within a healthcare system. And so if the medical community wakes up first and starts to protect and get together and speak up, I remain hopeful that this can change, not tomorrow, but over the next few years, hopefully.
Thank you for that. And Professor Franklin, I will leave you with our last bit.
Okay, the election could not be more important. If you want to see the plan on the right, go look at Project 2025. It lays out the plan for a Republican administration, including the interpretation of Comstock as a national abortion ban, which the expectation is will be put into place if Trump wins the presidency, among many other things. It couldn't be more determinative of reproductive health care. It is incredibly important. I think it's really tough to ask a constitutional lawyer while the cases are coming down what my hope is. It's not a good week. It's not a good week. Here's what I will say. Okay, one, what has been said, which is the bravery and the dedication and the kindness and the brilliance of the other people on this call. I really think about you every day, and I really admire what you're doing. Thank you. I guess it has a dark side, but the light side is this. Look at what the Supreme Court did. I don't think it's great that they are paying this close attention to electoral politics and let it drive what they're doing. But I genuinely believe that we got the outcome that we did because the mid conservative justices didn't want Trump to have to run with the bad EMTALA decision hanging over him because it's so brutal and cruel and wrong and the American people don't support it. So they pushed it till after the election. That means they are listening and somewhat responsive. They are aware that the American people don't agree with this radical agenda. And that's why that's why they punted everything so that it didn't have to sit on the Republican candidate who they want to win. That's bad in all sorts of ways for constitutional law and the court and our government. Put that aside for a minute, though, and I will just say they are listening, even if for craven reasons, they're paying attention. So people need to talk and to speak and to be out there and to write and call and discuss and do democracy because it can have real effects. It did this summer and it can have even better effects in the future. And this is not the worst place that a movement or an issue has ever been in our history. We had decades and decades and decades of slavery and Jim Crow, and those people fought, and we can continue to fight, okay? And so this is part of a long-term project and a legacy of fighting for freedom in this country that we're part of, and we all are so hopeful because we're sitting here and because we're doing what we're doing, and we have the people on our side, and that's a beautiful thing. So I do think we will prevail in the long term.
Thank you for that. Thank you from truly the bottom of my heart to each and every one of you for what you do every day, for being here with us today and taking time out of your very busy lives, and for sharing the perspective that you did. We appreciate you so much. And I appreciate everyone who is a participant on this call who took time out of your day to hear us. We really appreciate you. I know we've gone over, so I'm going to close, and I just really want to thank you all. So thank you. Have a wonderful day, everyone. Bye-bye.